Okay, welcome back to the deep dive. I'm really looking forward to what we're unpacking today.
Me too.
It touches on so many aspects of everyday life, sometimes
hmm
without us even realizing it. We are taking a journey into the often complex world of civil litigation.
Right. It's, where disagreements end up when people just can't work them out themselves.
Absolutely. And for this deep dive, our source material gives us a really practical angle. We're drawing insights from excerpts related to attorneys Jonathan Haskell and Matthew Dyer.
Focusing on their experience in Maryland.
Right, exactly. Their work navigating these waters in Maryland.
And the material seems to give a pretty clear picture of the common disputes people run into and maybe a certain way of handling them.
That's the idea. So our mission here is really to distill the key areas of civil litigation that these sources highlight. We want to understand the kinds of conflicts that typically arise.
And importantly, why getting experienced guidance is presented as so crucial, especially, within the Maryland legal system.
Precisely. So this deep dive, it's really for you, the listener. Maybe you're just curious about how the system handles fights over property or business deals.
Or perhaps you're facing an issue yourself, or think you might be. The goal is to help you get a clearer, more well-grounded understanding.
And judging by the material, we'll be spending a good chunk of time on contracts and real estate. They seem to be major focus points.
Yeah, those are big ones.
But we'll definitely touch on other related areas the sources bring up too.
Okay, so where do we start? I think one of the first things the material really emphasizes is this client-centered idea.
Right, that legal help shouldn't be generic. It needs to be tailored,
Yeah.
right, to the specific situation, the individual's goals.
Exactly, not a one-size-fits-all approach. I saw that too in the FAQ sections of the sources. They talk a lot about personalization and how experience plays into that.
Yeah, what really struck me was their stated belief that every single case is unique, that it needs undivided attention to get to those personalized solutions.
And they mention honing this over thousands of cases. That suggests, a pretty broad base of real-world experience across all sorts of disputes.
Okay, so building on that foundation-tailored advice, lots of experience. Let's get into the actual types of civil litigation the source material digs into. First up, the cornerstone, contract disputes.
Ah, yes.
The sources call them complex and demanding.
And they really are. I mean, think about it. Contracts underpin so many relationships. Personal ones, business ones, especially here in Maryland. Disagreements can just, pop up anywhere.
And the material suggests that having that deep experience helps avoid common mistakes and pitfalls.
Makes sense, knowing where things usually go wrong.
So the sources give some clear examples, like breach of business partnership agreements, partners falling out because one side isn't holding up their end, maybe hurting the whole business.
Oh, definitely. And employment contract issues, those are huge too.
Yeah.
Things like non-compete clauses, salary disputes, maybe wrongful termination claims. Really sensitive stuff impacting people's livelihoods.
Construction contracts seem almost notorious for disputes, delays, shoddy work, people not getting paid. It's a classic.
It really is. And then lease agreements. So many people deal with these. Disputes over terms, maintenance responsibilities, security deposits, eviction battles even.
The sources also mention insurance contract disputes. Your claim gets denied or they undervalue it. That happens a lot.
Yeah. It's pretty clear from all those examples that just misunderstandings or failures in agreements, written or maybe even verbal, are a massive source of conflict.
Okay, let's pause there for a sec. Why is understanding these common contract scenarios actually important for you, our listener?
Well, because contracts are just everywhere, aren't they? Recognizing these typical problem spots might help you see potential issues before they explode.
Right, maybe be more careful signing things.
Exactly. It highlights the risks involved if things aren't clearly defined. And look, if problems do come up, trying to navigate that legal maze without help, the sources suggest that can lead to serious financial consequences or just, bad outcomes.
Okay, good point. Let's shift gears then. Another major area the sources focus on, often with even higher stakes, is real estate disputes. The material points out their complexity, partly because of the sheer value of property, but also, let's face it, the emotional connection people have.
Absolutely. Your home, your land, it's personal. And these disputes, they cover a huge range, from problems during a sale, like you mentioned, or lease disagreements, to really fundamental questions about who owns what, property rights themselves.
And the sources stress needing a deep understanding of real estate law to handle these.
Which makes sense. It gets technical fast.
So examples they give include the classic breach of purchase agreement, buyer or seller backs out or fails to meet their obligations after signing.
Happens all the time. And property line and boundary disputes, these are incredibly common. Just disagreements over where your yard ends and the neighbor's begins. Simple, but can get very heated.
We see landlord-tenant issues again here, but
Mhm.
tied specifically to the property itself.
Mm-hmm.
Arguments over rent, security deposits again, who fixes what.
And, unfortunately, foreclosure disputes. Challenging the legality or the process when someone's facing foreclosure.
The sources actually list a whole lot more too. Things like zoning issues, easements, which I think we'll get to construction defects discovered later, problems with the property title, claims someone misrepresented property during sale.
Even disputes between co-owners. It's a long list.
And I remember seeing in the FAQ section something about Maryland-specific challenges, like specific rules around adverse possession or boundary laws here.
Yes, exactly. And that's where that local experience, the kind highlighted in the sources about attorneys practicing in Maryland, becomes so critical. State laws, local court precedents, they add layers that someone without that specific Maryland experience might just miss.
Okay, moving on. Another area the sources identify is contract interpretation itself, as in the act of figuring out what a contract means is a huge source of disputes.
It really is, because if two people read the same words but walk away with different understandings, well, you've got a problem brewing.
So the challenge is clarifying what the intent was, getting behind the words.
Pretty much. The sources talk about needing to dissect, complex legal jargon to find the true meaning and intent the parties likely had when they signed on the dotted line.
Can you give a simple example, like how language could cause trouble?
Sure. Imagine a contract says work needs to be done in a reasonable time frame. Simple phrase, right? But what's reasonable? 2 weeks, 2 months. Very different interpretations.
Oh, okay. I see.
Or, say, a service contract has 2 clauses that seem to contradict each other slightly. Which one wins? That's an interpretation issue right there. Conflicting terms.
Got it. And the sources list examples like ambiguity of business agreements or figuring out those tricky non-compete clauses. What area, how long, is it even fair?
And insurance policies are famous for this. Disputes constantly arise over what specific words mean in terms of coverage. Is this specific event covered or not? It all hinges on interpretation.
Yeah, that makes sense.
And really, avoiding the fight by having clear language up front, that's often just as crucial, maybe more so, than winning the argument about ambiguous language later.
Okay, speaking of making sure things happen as planned, the sources talk about something called specific enforcement, which sounds like sometimes money isn't enough. You need the other person to actually do the thing.
That's exactly it. Specific enforcement is basically a court order telling someone they must perform their specific promise from the contract.
Okay.
As the material points out, you'd ask a court for this, usually when just getting money wouldn't really fix the problem for the person who was wronged.
Right. And the examples listed show this clearly. Enforcement of real estate sales agreements, forcing a sale to go through because that particular piece of property is unique. Money wouldn't be the same.
Exactly. Or fulfillment of construction contract terms, making the contractor finish the building project they agreed to, not just pay damages for walking away.
Implementing non-compete conditions, actually stopping a former employee from competing unfairly, like they promised they wouldn't.
And enforcing settlement agreements. If you reach an agreement in mediation, say, this makes sure the other side actually follows through on what was agreed.
So it's a tool to make sure the agreement is, as the source says, honored as intended.
Precisely, when performance itself is the key.
Okay, here's one that always sounds a bit unusual. Adverse possession. The sources mention helping clients with this, either making a claim or fighting one off.
Yeah, it's a fascinating legal concept. Basically, it allows someone to claim ownership of land they don't technically own just by using it openly, continuously, and without permission for a long time.
So it's not just squatting. It has to be obvious.
Right. The use has to be prolonged, open, and notorious. The idea is the actual owner could have known about it and had the chance to stop it.
Okay, the examples in the sources make more sense then. Like long-term residential property occupation and someone literally living on property they don't own for many years, acting like the owner.
Or using vacant land consistently, maybe gardening on it, storing things there year after year without permission.
Expanding into adjacent unused land, like building a fence or planting shrubs that cross the property line onto neglected neighboring land, and it stays that way for the required legal period.
Yeah, the sources even mention things like occupying abandoned buildings or using a private road across someone else's land for years.
It sounds like there are very specific legal hurdles, though.
Oh, absolutely. The sources mention legal complexities. In Maryland, you have to prove several specific things. The possession must be actual, open, notorious, exclusive, hostile meaning, without permission, and continuous for 20 years. It's very fact-specific.
That seems to tie closely with boundary disputes, which we mentioned under real estate. Resolving these, the sources say, needs legal knowledge, but also often good negotiation skills.
Definitely. They often start from something simple like unclear property lines or misinterpretations of land surveys. The process involves digging into property history, deeds, surveys, and trying to negotiate or mediate before resorting to court.
And the examples are things people can relate to. Disagreements over fence lines, classic neighbor dispute.
Or issues with overhanging trees and branches causing problems.
Encroachment of structures, someone's new shed or deck extending onto your property.
And sometimes you get conflicting survey reports, which really muddies the waters.
So the goal here is just protecting your property rights, making sure the lines are clear.
Exactly. Defining and protecting the extent and use of the land.
The sources also specifically call out construction disputes, again, separately, noting the significant sums of money and complex contractual relationships involved.
Right. It's a separate focus because it's so common and involves so many parties, owners, contractors, subs, suppliers. The material points to issues like project delays, claims of contract breach, substandard workmanship, construction defects discovered later.
So legal help here might range from reviewing contracts before signing to full-on litigation if things go wrong.
That seems to be the scope mentioned. Things like fighting over project delays, arguing about the quality of the work, or finding serious problems after the job is supposedly done.
It sounds like these often need comprehensive legal help, just to sort out who's responsible for what.
Given the complexity, yes. That seems to be the implication.
Okay, then there's easement and right-of-way disputes. This sounds like rights to use part of someone else's property for a specific reason.
That's a good way to think about it. An easement gives one party a legal right to use another's land for a limited purpose, like needing to cross their land to get to your own property or for utility lines to run through.
And does these get complicated?
They can be very intricate, yeah. You often have to analyze old deeds, understand land use laws, figure out how the easement was created maybe decades ago, negotiation, resolution, sometimes litigation.
So examples the sources give include disputes over access easements, maybe a neighbor blocking a path you have the right to use.
Or utility easement encroachments. Someone builds something that interferes with underground pipes or wires that have a legal right to be there.
Disagreements on the exact boundaries of the easement itself.
And similar to adverse possession, there's something called easement by prescription, arguing you've gained the right to use a path simply because you've been openly using it for years and years.
So again, it's about protecting specific rights related to property use.
Exactly. Protecting client rights and interests in these very specific situations.
Okay, last major category the sources cover, landlord-tenant disputes, described as particularly contentious.
And they often are because it's about people's homes or their places of business. Very common, can get heated fast.
The material lists a range of issues: eviction proceedings, fighting over security deposits, disagreements over lease terms.
Right. Things like non-payment of rent leading to eviction, security deposit arguments, will you get it back, lease violations, unauthorized pets, subletting without permission.
Also, disputes over property maintenance and repairs. Who fixes the leaky roof or the broken heater?
And the eviction process itself has very specific rules in Maryland, leading to legal challenges.
And the sources mentioned representing both landlords and tenants.
Yes, highlighting the need to ensure rights are respected and upheld for whichever party they're representing within the lease and Maryland law.
Wow, okay, so we've really covered a lot of ground, drawing from this material related to attorneys Haskell and Dyer. Everything from basic contracts in real estate
to the finer points of interpretation, specific court actions like enforcement, those unique property issues like adverse possession and boundaries.
Specific sectors like construction, easements, and landlord-tenant conflicts. Quite a landscape.
And weaving back to that Maryland context, the sources emphasize it really drives home how navigating these areas effectively often depends on experience with the specific laws and court procedures right here. That local knowledge seems vital.
So let's bring it back. What does all this mean for you, the listener? We've taken this deep dive into civil litigation, guided by the source material looking at common disputes.
Well, understanding these scenarios isn't just, academic. It's about awareness, recognizing potential legal traps in everyday agreements or property issues, appreciating the complexity.
And seeing why getting help matters.
Exactly. Seeing why experienced legal guidance, like the kind the sources discuss, can make a huge difference in navigating these situations well and hopefully avoiding costly mistakes.
It really highlights how many normal interactions, signing a lease, an employment contract, agreeing on a fence line with a neighbor, carry real legal weight. So let's leave you with a final thought inspired by the material.
Consider how often you enter into agreements or deal with property boundaries. These actions rest on legal principles. If they're misunderstood or challenged, they can spiral into really complex, draining legal battles.
It truly underscores the value of getting things clear from the start and knowing when it's time to call in expertise.
Thank you for joining us for this deep dive.
Until next time.